looked at. Now, the next reform we shall look at relates to renewal clauses in contracts and leases. You know, there is a problem people have encountered in some parts of the country. And that problem is that people end up acquiring the land, they acquire a lease for 45 years, for 50 years, and they build a mansion on the land. And then, when the lease expires, and the landowners come and they say they want the building back, you will see the tenant saying that, oh, but at the end of the day, let us renew it. Why do you want us to leave this whole 5-story building here and give it back to you? Now, the law is that when it comes to renewal process, it must be an express term of the contract. In other words, if you are buying land and you are preparing the lease, you must make sure that if you want to renew it, there must be an express provision in the agreement that will confer the right on you, the lessee, to renew it. In other words, if you go and buy the land and then there's no renewal clause, when the 50 years elapses, please pack your things and move out. You cannot compel the landowner to renew it for you. And I'll demonstrate this to you with the case of Miracle and Tete, deceased. Iwe Miracle versus Tete, reported in 2011, one Supreme Court of Ghana law report at page 520. Listen to the words of the learned Supreme Court Justice, Edinua GSC, and listen to how she treats renewal clauses. And I'm quoting. I'll go at a very slow pace so that you get a full import of the statement. Edinua GSC says as follows, and I quote, a lease agreement is a contract for the lease of land, and thus the terms of the contract has to be by mutual agreement. Whereas some covenants by the lessor or transferor and the covenants by the lessee or transferee are implied by common law and statutes, the option for renewal is not. I'll take that portion again. Whereas some covenants by the lessor or transferor and the covenants by the lessee or transferee are implied by common law and statute, the option for renewal is not. Accordingly, the option for renewal can only be conferred on the tenant by express mutual agreement of the parties and ought to be an express term in the lease agreement. End of quote. What does this mean? It means that if you're going to buy a land at cantonment and you've acquired the lease for 35 years and there's no renewal clause, when the 35 years comes, avoid embarrassment, pack your things and move, because the renewal clause must be an express clause. That's what we saw in Iwe Miracle versus Tete, reported in 2011, one Supreme Court of Ghana law report at page 520. But this case of Miracle versus Tete, it didn't even proceed as follows, and I quote, a lease agreement is a contract for the lease of land, and that the terms of the contract has to be by mutual agreement, that the option for renewal can only be conferred on the tenant by express mutual agreement. So if there's no express mutual agreement, then you don't have an option for renewal. Miracle versus Tete, 2011, one Supreme Court of Ghana law report at page 520. But because of the injustice that this can cause, that if you go around Accra, people who may end up losing their houses and they may not have any place of abode, there has been a reform that has been introduced. And this reform, you can see it under Section 50, Subsection 9 of the Land Act. But let me tell you what it says. You need to pay critical attention to these reforms. Now, the reform are in different phases. The first phase is that where land is granted by the allodial or usufructuary holder to an indigene of the area where the land is situated. Note carefully, where the land is granted by the allodial holder or the usufructuary holder to an indigene of the area where the land is situated. That one, the law says that there must be an automatic renewal. Look at section 50, subsection 9 of the Land Act of 2020, Act 1036. It reads as follows, and I quote, where a lease in respect of bare land is granted by a person who holds an allodial or usufructuary interest in the land, and the lessee is an indigene, and the lessee is an indigene, and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed A, the land for residential purposes, B, a farm of perennial crops on the land, or C, a commercial or industrial property on the land for the same duration as the original lease when the lease expires. So it means that today, that case of Miracle versus Tete, 2011, one Supreme Court of Ghana law report at page 520, it will be that law, it will be bad law. We have given the case a decent burial. Because now we are saying that where the lease in respect of bare land is granted by a person who holds an allodial or usufructuary interest in the land, and the lessee is an indigene of the area where the land is situated, the lease is subject to automatic renewal where the lessee has developed the land for residential purposes, a farm of perennial crops on the land, or a commercial property or industrial property on the land. And the lease is supposed to be renewed for the same duration as the original lease when the lease expires. And you realize I was emphasizing on the grant from the allodial holder or from the usufructuary holder to an indigene. That is where you have the automatic renewal. Now, if you read further, there's another clause that deals with the grant in respect of leases to a citizen who is not an indigene. That one, the law treats it differently. So, the first one I looked at was in relation to you acquiring the land from the holder of the allodial interest or the holder of the usufructuary interest, and you are granting it to an indigene. That's one, you have an automatic renewal. Section 50, Section 9 of the Land Act. But there's also a grant to a citizen who is not an indigene. And that one, the law treats it differently. If you look at Section 50, Section 11, this is what it says. Unless otherwise expressly provided in the lease, where bare land is leased to a citizen of Ghana who is not an indigene. Emphasis, leased to a citizen of Ghana who is not an indigene of the area where the land is situated. There shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. There shall be an implied term in the lease that the lessee is entitled to a renewal of the lease. Now, what does this even mean? It means that first of all, it must be a lease of a bare land. Number two, it must be leased to a citizen of Ghana. Number three, that person must not be an indigene. In this case, it says that it shall be an implied term that the lease is that there will be a renewal clause, that the lessee is entitled to a renewal of the lease. Now, what is very phenomenal in this portion is the opening sentence, which reads, unless otherwise expressly provided in the lease. Meaning that if you are a citizen, you are not an indigene. and you're going to acquire a land, in the document, it could be put over there that you do not have a right of renewal. It means that if the parties agree and put over there that this lease shall not be renewed, the court will give effect to that one. Listen carefully, because section 50, subsection 11 says, unless otherwise expressly provided in the lease. What does this mean? It means that in the lease, the parties themselves can agree to the contrary, that they don't want any renewal. When you do that one, the court will give effect to that. But as it stands now, section 50, subsection 11, which says that there shall be an implied term that the lessee is entitled to a renewal, it shall only kick in when the agreement is silent. It means that if you are a citizen, you are not an indigene, and you want to acquire a lease, if the agreement is silent, there's no clause that deals with renewal. The law is importing a renewal clause in the lease. But remember, this applies to a person who is a citizen, is not an indigene of the area where the land is situated, and the agreement is silent on whether there's a renewal clause. So if you compare this to the first one we looked at, you realize that when it is granted by the holder of the allodial interest or the holder of the usufructuary interest, and they grant it to a lessee who is an indigene, that one, there is an automatic renewal. But if it comes to granting it to a person who is a citizen who is not an indigene, then that one is an implied term. By that implied term, the parties can agree to the contrary, because we've seen in the opening words that says that unless otherwise expressly provided in the lease. So you've seen two categories of the renewal. First one dealt with a person acquiring from the allodial holder or the usufructuary holder, and that person is an indigene. That one, automatic renewal. You've seen the other category, it's acquiring by your citizen, you are not an indigene. That one is an implied term. By this implied term, the parties can agree to the contrary. Now, let us look at the third category of renewal. The third category of renewal, that is our next reform that we are looking at, is captured under section 50, subsection 12 of the Land Act of 2020, Act 1036, and it reads as follows, and I quote: a lease of bare land, a lease of bare public land granted by the Republic to a citizen of Ghana, a lease of bare land, a bare public land granted by the Republic to a citizen of Ghana is subject to automatic renewal on terms agreed upon by the parties. Meaning that this one is dealing with acquiring a lease by a citizen of Ghana from the government of Ghana, public land. That's one to automatic renewal. But take note of the caution that we are told that section 12 does not apply where the lease is in respect of a commercial property or the lease property is required for redevelopment. Then that's one, the automatic renewal will not kick in. So take note of section 50, subsection 12 of the Land Act of 2020, Act 1036. Then, let us look at some interesting provisions so far. But before we look at the provisions, remember the different categories of renewals we looked at. First one is relation to acquiring land from the allodial holder or the usufructuary holder and acquiring it to an indigene. That's one, automatic renewal. Second category was acquiring the land to a citizen of Ghana who is not an indigene. That one is an implied term that there can be renewal, and that one the parties can agree to the contrary. And remember the next one, lease of a bare public land granted by the Republic of Ghana to a citizen. This one, automatic renewal. But it doesn't apply where the lease is in respect of a commercial property or the lease property is required for redevelopment. Now, let us look at some provisions about this whole renewal. Look at section 50, subsection 14 of the Land Act. This is what it says. Because This provision is important because somebody will be wondering that if you are renewing, how are we going to determine the new rent? Because I leased the property in, let's say, 2010, now in 2070. How do we determine new rent if you are saying there should be a renewal? What will happen if there's a disagreement about the new rent? How do we deal with it? The law has an answer for all of you. Look at section 50, subsection 14 of the Land Act of 2020 at 1036. It reads as follows, and I quote: the renewal in subsection 7, 9, 11, and 12 are subject to the original terms of the lease, and any new terms agreed upon by the parties to the lease or their successors, agents, or assignees, taking into consideration any improvement on the land by the lessee. Then section 50, subsection 15 reads as follows: where the parties fail to agree on terms for the renewal of the lease, the dispute may be resolved under the Alternative Dispute Resolution Act of 2010, Act 798. That's a very important provision. If after 70 years they are renegotiating and we cannot agree on the amount of money you are going to charge for the place, it may be resolved under the Alternative Dispute Resolution Act, which is very important because over there, when you go, we are not going to waste time. ADR is very fast as compared to court. But if you are the parties and you fail to take advantage of the ADR mechanism, the answer is there for you under section 50, section 16. It says that if the parties fail to resolve the dispute under section 15, the parties may settle the dispute in court. You see? So, if the time comes and we can't agree on the renewal, how much I'm going to pay, the law says that we may resort to ADR. But if we don't take advantage of the ADR, then we may resolve the dispute in court. You remember when I was giving you the different categories of the renewal, we looked at the renewal in respect of the lease by an indigene. We look at one by a non-indigene, and the one in respect of a citizen of a public land. Look at section 50, subsection 17. It deals with Ghanaians, non Ghanaians. It says, subject to subsection 6 of section 10. A lease for a fixed term granted by a Ghanaian to a non Ghanaian is not subject to renewal unless the lease expressly provides otherwise. So if you are not a Ghanaian and you've acquired a land, the law is saying that there is no implied term that there's going to be a renewal. That lease is not subject to a renewal unless the lease expressly provides otherwise. Meaning that the parties still have the chance to agree that you are a foreigner, acquired a lease for 30 years, but it can be renewed for an extra 30 years or 40 years. So they say that a lease for a fixed term granted by a Ghanaian to a non-Ghanaian is not subject to renewal unless the lease expressly provides otherwise. So let us say that the agreement between a Ghanaian and a foreigner has a renewal clause. That one, it will apply. But if there's no renewal clause, then please, then there's no renewal clause. You cannot force the person to renew for you. So look at section 50, section 18. It says that where a non-Ghanaian exercises an option to renew a lease, the renewal is subject to the agreed terms upon by the parties. When a non-Ghanaian exercises an option to renew a lease, the renewal is subject to the terms agreed upon by the parties.